Testing 1 2. Testing 1 2. Oh. Testing 1 2. Testing 1 2. Testing 1 2. All right. Today, as you see the title, I'm your host, Supreme Decisions, and I want to go into this because it actually kind of sparked a reason for me to actually put this down. Because I've been defending or helping people, guiding them through their legal cases, and I wish I could say it was like a one-off, but I've had several clients in the midst of a trial or something, or in the midst of setting up their defensive strategy, something gets sent back. And I'm like, why? Where did this come from? They'll be like, oh, yeah, because that was something else. Like, no, I need to know these things because now I have to have a different strategy for what we're going into. Because again, remember I told you once before, I deal with expectation management. So whenever I'm not told everything and I get blindsided by something, it can disrupt the entire strategy we have planned. Or now I have to deal with this separate situation in order for us to continue in a course which gets you to where you're trying to get to in the original situation you had me guiding you for. And it also pisses folks off because now you got to spend more money because you have a separate situation that you didn't tell me about. Now, this actually got sparked because I was literally laying down and I was watching the show. And it was something that was brought up during the show. So I was like, you know what, that'll be great because I have this exact same issue, not once, not twice. I want to say at least 10 to 15 times. And people have gotten upset with me because I told them, hey, this one isn't free, but this is a problem because you didn't tell me this to begin with, and it disrupts our original strategy. So this is a deep dive question. And this was also something that was brought up. Their scenario was in the midst of a murder trial. Why is it important for a defense counsel to know if the defendant did it and who else made note about them committing this murder? Now, I'm going to frame it in the midst of not just the murder, but in any situation. Let's say it's a fight. Let's say it's pretty much anything, right? Because even if we're dealing with a foreclosure, or I'm helping you stop an eviction, or I'm buying you time for who knows what, but there's something else that's in your past or that's currently going on, like you're out on bond. I need to know these things when I'm placing your strategy together. That's crazy. All right. Why is the defense attorney needs to know if the defendant did it? Now, again, this is addressed and set up as if we're obligated during for a murder, but again, this applies to everything. Now, the ethical obligations: a defense attorney cannot knowingly let a client commit perjury or lie under oath. So, one of the things that I teach in the masterclass is going to be the defense needs to hear you are innocent. Someone saying that has done an offense cannot be the one to say they didn't do it and it was actually committed, because even the strategy can't be catered towards them not doing it. I'm gonna let you understand it. The strategy can't even be catered towards them not doing the thing. So even in the context of doing that, the defense, again, the jury needs to hear that they didn't do it. Now, if the defendant cannot say, I didn't do it, but there's a means for proving it or a strategy that gets the jury to that point, it needs to be known prior to. Because even in the context of any of this, this needs to be worked out and it needs to be prepared for. Right? The lawyer cannot put the person, the defendant, on the stand. So even in the context of doing that through the ethical obligations, you have to be able to say it. Because again, I'm gonna give you something. My trial, my RICO trial, and I'm resting on this a lot because this is my greatest experience. One of the things that we planned on was you had 3 people sitting up there. 2 of them could not take the stand whatsoever because there is no way I could have gotten on the stand and my history not be brought in and my tendencies not be brought in. My brother, he couldn't be called in because he was with me during at least 50 to 60% of the stuff that was being addressed on the stand. So we did have a brother that was also sitting there, Alicia. He was as close to a saint as anyone could be. Like, he didn't have a criminal record. He had never been arrested. Like, it was the most profound thing I'd ever seen in my life. He had never been in the legal system ever in life up until that point. So when he got on the stand, there was nothing in his background that could have been brought up other than the fact that he was an A student, he was a scholar, and he had never been arrested. So those are also plus. But when he got on the stand, one of the things he said, he never said he didn't do it. What he said was, if I did something illegal, put me in jail. I should be there. And I was like, why in the hell would you say that? You know, because we told him to go up there and freestyle for the most part. But I asked myself, why would you say that? He said, because that gives them an opportunity to know if I'm that confident in my innocence that they have to look at the evidence differently. Because again, he's a scholar, he's a thinker. So whenever he didn't say anything that wasn't addressed or on purpose. But the jury had to hear we were innocent. And that was his way of framing it without saying the actual words. But remember, it can't be done if you did it. And there are other things, because there has to be a strategy in place that protects not only you, that protects the situation, also protects the person that's helping you. Now, the strategy, the approach to trial depends on whether the case is about actual innocence or reasonable doubt. And our case was towards reasonable doubt. I'm going to say that again. It wasn't about innocence. It was about reasonable doubt that we actually committed the crime. Because we did 90% of the stuff that we did. The problem is we followed the legal path and way to do it. It was so in your face that we got arrogant about it. We forgot that this is not something that should be shown to the masses. And we were a steamroller, and we was a bull in the china shop. Excuse me. Because everything I did was forceful and it was blatant. And the best way to describe it was, a lot of times I even describe myself, I'm a hammer and everything to me looks like a nail. So it was always hit, hard, fast. And even with the strategy, it was always straight out 100% attack until I actually understood that there are certain things that need to be done that can be done more finesseful that gets you the same results. And that's when I was like, okay, let me master my craft. Because it's hard to believe that in 2012, yes, because that's when this was, 2012, how much of a blunt object I was and how I was perceived to be so dangerous then. To, well, now 13 years after that, I am more of a refined artist, and things that I do is now being perceived and understood to be what it's supposed to be. The mastery of my actual craft, because I don't just do this. And this is why I told you, I actually saw this coming when I did the interview, the radio interview, in I want to say 2016. And everybody there at the time, I think I had 100-something videos. And they asked me how many would you go? And I told them, I said, I'll have at least 1,000. And right now I'm sitting on the outskirts of 780. And more videos are coming. Because I understand there's a reason why someone goes to school for 7 years to learn this, to actually have an opportunity to take a test. Just let that sink in. They go to school for 7 years to have an opportunity to take a test. And that's why this is the way it is. Because I understand this on a different level than most people do. Because I don't only understand the law itself, I understand how to apply it. And I understand the principles and nuances of the law. So there are different strategies that can be taken in place, which is why I actually go into something like true believers, why it's effective, how it affects you, and even asking these types of questions. Why do I need to know everything? Because even in the strategy, if the defendant is innocent, I can build a case that's affirmative, such as alibis, alternative suspects. I can actually come up with a reason where I'm attacking the process, where I show that they did not follow police procedures. You know, I can go and show that they didn't do the totality of circumstances. They didn't interview actual witnesses. They didn't actually review cameras. These are things that are part of that keeping you innocent. Now, if the defendant did it, I'm going to say that one more time because, again, I also have done a couple of murder trials. And, well, murder cases, they never went to trial. If the defendant did it, again, pretty much the same principle. The only difference is you go at it at a much higher rate. You must focus on suppressing evidence, challenging procedures. Because, again, what did I just say? The Fourth and Fifth Amendment violations, or negotiating a plea rather than arguing pure innocence. Now, the negotiation of a plea is the absolute last resort because you don't want to fight. I'm going to say that one more time. Negotiating a plea, if you're coming to me, is the absolute last resort, and that's because you don't want to fight. Because to me, accepting that plea is telling them what they did was okay. When, again, I told you in True Believers, they don't know law. They don't do procedures properly because they don't know them. They don't actually even understand how it applies in all situations. So that's why I say it's a last-ditch negotiation, because I'm going to place liability on them. Oh, you arrested him? Well, we need to see your background. We need to see what you learned. We need to see how long you've been screwing up. Because, again, if you start giving me all this information, I can now go into your actual history and start taking that apart, and I can show a pattern of badness. And that's the police officer or the prosecutor, because I've done both. Now, the number one reason why someone that's guiding you or your defense attorney needs to know everything is to avoid surprises. Because if your counsel does not know the truth, they may make arguments or promises to the jury that backfire when unexpected evidence comes up. Again, it's any number of things that can come up. Like a stray video that you didn't know, because, again, I've talked about that with the DA. He didn't know there was a video that existed that showed that he was not being honest or truthful about how his officers had been contacted in the case where the police officers murdered a young man in his front yard, in which the district attorney stated that they came in contact with the vehicle But he didn't say that they touched the vehicle while he was driving. Not that he drove at them, but he was driving away from them, and they touched the vehicle and then shot him and used that as an excuse to justify their action. But again, anything that you don't tell cannot be defended. You can't defend something you don't know. And that's the whole point of making sure everything is known, everything is on the table. And the big instance of why does it matter who else knows? Now, if you look at again a case that I've worked before. I asked my nephew who was with you whenever he had an issue. The reason why I asked that was because I need to know if someone else is there that could possibly tell a different story. And when he was like, "Oh, I was by myself," okay, I know exactly what you did. You don't even have to tell me the rest of the story. And what it does, it gives you witnesses and evidence risk. If other people know, the prosecution may call them as witnesses. The defense needs to anticipate damaging testimony and prepare cross-examination or impeachment. Again, this is why whenever we're talking about regular stuff, as far as, let's say it's a traffic citation, I need to know if they're using that officer's report to charge you. I need to know that officer's impeachment information. I need to prepare just in case we have to cross-examine him because his testimony is damaging because his word is accepted as truth. Why? Because it's signed under oath and penalty of perjury. Most people don't understand this. And this is why I'll say, okay, get this. And they don't know why. And then I say that, and it's like, oh, the light pops on. And then what happens is now, whenever we're doing these things, it becomes relevant because not only is it something that I can now impeach you for, but I can now hold you responsible for everything that's going on. Now, discovery and investigation. Knowing who else knows helps the defense investigate whether these individuals are reliable, biased, or have incentive to cooperate with the state, and sometimes in exchange for leniency in their own cases. And this is why I'm also going to do a video on why there must be a disclosure of any government incentives. Privilege and confidentiality. The lawyer needs to understand how far attorney-client privilege extends and whether third-party disclosures could weaken the defense strategy. Now, this is where you're talking about if you're, let's say you're meeting with your counsel or you're meeting with your attorney. Third party becomes anyone that is sitting there because you allowed it. They can now be called to testify against you because they have no attorney-client privilege unless it's a spouse or it's a parent that's there with a minor as a defendant. They do not, anyone sitting while you're having conversations about your case is now a witness in your case. I constantly tell people, and it's the most irritating thing I've ever dealt with in my life. I tell people, stop talking about your case to everyone because everyone you talk to is not your friend. And anyone that gets in trouble can now testify against you. Why? Because you've given them ammunition against you. You are arming your enemy without knowing it. Now, it may be harmless until. Always understand it's harmless until you tell anyone anything. They are now potential witness against you. And let's say they don't really like you. You think they're your friend, and when in fact they're your closest enemy. I'm going to say that one more time. You think they're your friend, when in fact they're your closest enemy. So keep an eye on your enemies, watch your homies. Because again, like I constantly tell people, and it's dumbfounding to me. Because I tell people, a lot of times when you're getting booked up in these big cases, I actually had a Homeland Security case that I helped a young man with. And you want to know who snitched on him or who tried to set him up? His brother. His actual brother. His blood brother was the one who set him up. Whenever I told him, because I got the paperwork, and I'm looking over the paperwork, because he didn't know what he was looking at. I said, go to page 22. He's, what's on page 22? I said, whose name is on there? He said, oh, that's my brother. I said, that's who's snitching. No. My brother wouldn't do that. My brother wouldn't do that. My brother wouldn't do that. And all of a sudden, his brother got money. His brother's disappearing. And I told him, your brother's the snitch. Your brother is the one who is doing and feeding them information. That's why whenever you go and do something, it's right after you told your brother and they're catching you. They're running up on you. I said, here's the thing, run a test on it. Just run a simple little test on it and see what happens. And it wasn't until he ran this test that he realized that his brother was communicating against him. He ended up winning the case, but he also had to disconnect from his brother. It is one thing I understand more than anybody else. Because again, I actually gave the context, because we won the case October 25th, 2012 at 1:04 p.m. That's when it actually got the verdict, and literally seconds later, AJC dropped it. We crashed the page. Right after that, November 12th, 2012, 1:04 p.m., I'm driving down I-20. I'm on the phone with my brother. My brother tells me something, and I yell out the time. That's the only reason I remember it. And he goes, why you did that? I said, because I'm announcing the time of death because you are dead to me. Because at the time, I understood right then I had sacrificed everything for him, and it still wasn't enough. He still wanted more. And then he was telling me I was the one that was the problem for him. So I then decided, since I'm the problem, you never have to deal with me again. I always understood that. And even him, what he didn't realize, because he still did not accept, even though we showed him in writing, his best friend was the one who initiated all the stuff against us. I actually had a young lady that she was a soccer mom. She was arrested and charged with manufacturing and distribution of meth. And I told her, your sister is the one that's doing this. Oh, no. Found out it was her sister. Because again, they're going to put it in writing. And that's what you have to do. And most people don't understand how to ask for these things. And then the next part of it, they don't understand how to accept when they find out the actual reality of it. Because again, like I tell you, everybody's strong with no resistance. The second pressure's been put on somebody, they show you exactly who they are. And once you do something, I want you to believe exactly who they are and expect nothing else from them. Expect them to be weak. Expect them to not be able to stand up with you. But it also accept that they are weak. Accept that they can't stand with you. Because even if you're not doing something wrong, they'll actually paint you in the light in which you are. Because again, like I talked about in my case, there were several people that took deals to actually go to prison. And they couldn't figure out what they had done wrong, what law they had broken. But then you have one dude, he took a deal right before trial. He got upset with me because he took a deal to go to prison, and I went home. He actually sat in the courtroom with an attitude when the verdict was announced. Because see, that was one of the things that I actually wanted to actually get into, because the mentality of most people is the fact that, why didn't you go? Because I thought I was saving me. When in fact, they're only saving themselves because they are too afraid to fight. And in the fact that we're doing this and going through these stages, understand there are also means of confidentiality. But even those confidentialities, such as husband and wife, they can be broken. A marriage contract is just that. It's a contract. You can break that contract. Either spouse can break the covenant. Because again, you're putting a third party, when you're signing that marriage license, into your marriage. That third, you, her, state. It's a three-party contract. And most people don't understand whenever you have that. This is why it can be broken. Because it's technically a unilateral contract, but only one person or one entity gets the actual benefit, and that's the state. So these covenants can be broken. So again, open discussions with everyone is not a good thing, because you are actually setting up the person that's going to be a witness against you, potentially. So, balancing ethics and defense. A defense counsel's job is not to prove innocence at all costs. It's to ensure the state proves guilt beyond a reasonable doubt while protecting the client's rights. Now, knowing whether the defendant did it helps the lawyer avoid unethical defenses while still zealously representing them within the bounds of law. Understand, a lot of attorneys won't even ask the question, but they still need the information. They still need to know if you did it. They still need to know if someone else seen you do it. I want you to understand that. They need to know if you did it, and they need to know if you seen it. They need all the information to prepare the proper strategy, because that's why, again, I approach the context of chess. When you're looking at the chessboard, both sides have all information. Now, the only difference is you have to request all of the information. And if you don't, that then becomes part of your moves, because even a pawn can become a queen, which means something small in the midst of this conversation or in the midst of your discovery request can then become the most powerful part of your case. Even a pawn can become a queen. Even the things that you look at as minute and unnecessary can be the things that set you free. But it has to be known by the person that's defending you or guiding you. You need to make sure these conversations are had and these conversations are accepted. Because knowing, again, if the client did it, helps the lawyers know the ethical structure of the defense. And a lot of times, you have to also know the tactics in which you can employ. And even what stance that you're going to take and what direction that goes in. Who else knows helps the counsel anticipate the prosecutor's case and prevent surprises. Because the one thing I've always told people this, because even my grandmother learned this hard way. I'm not a great person to surprise. I don't play along with surprises very well, because just to give you an example, my grandmother threw me a birthday party one day. Most beautiful thing I'd ever seen in my life. She didn't say anything to me. She didn't say anything to my wife. So when I got the phone call, hey, what time you getting to the house? I said, tomorrow. She goes, why tomorrow? I said, because we're in Atlanta. We getting something to eat. We party. She goes, well, I put together a party for you. I said, oh, you didn't say nothing. You don't surprise me. You got to let me know what's going on, because I'll go ahead and do my own thing. And even there's this thing called El Paso Fit Fam. And what they do, they actually put up a lot of videos from around the city. I'm on there 3 times. 2 of the 3 times is because someone tried to play a prank on me. And yeah, those pranks didn't end well, because I am too grown to be playing with somebody else's child. And both times, I actually grabbed the dude one time. The second time, I actually jumped up to punch him, because I'm not that guy. We're not playing. I'm gonna give you, hey, I got you. Go ahead, go on about your business. If you choose not to go on about your business, that means you want me to punch you in the shit. So understand I'm not the dude to surprise. I'm not good with surprises. And make sure if you're coming to me, you make sure I have everything to be prepared to defend you and guide you in a way that gets you to the outcome you're looking for. And this also is for what you need to do whenever you have someone that you're paying to represent you in order to force them into a zealous defense. Because I hate to say this, whether you did it or not, you are still open for a defense. Everyone is entitled to a defense. That's where I come in as a true believer. So thank you guys for watching. Stay tuned because even on, I want to say it's Monday, Labor Day, I'm going to be doing all day, or at least as long as I can event. I'm probably going to have to switch cameras a couple of times, in which I'm just going to be talking about law all day, literally all day. You can actually chime in, shoot a donation, ask questions, and we can keep rolling and keep going. And don't forget the super chats. Don't forget to join the channel. And let's keep going. Let's keep growing. Supreme, I'll see you at the next video.